The Supreme Court's about to weigh in on a case that could decide whether those gun-free zone signs actually carry any weight anymore. Wolford versus Lopez has the potential to crack open state carry laws in a way we haven't seen since Bruen, and the ripple effects could hit every corner of the country. Hello everyone, this is Scott from Line 45. Today, we're diving into how this case could reshape your day-to-day carry rights faster than most folks realize. Before we dive in, do me a solid. Smash that subscribe, tap the bell, hit all the dang buttons down there. You don't gotta, but it keeps this train rolling and lets me crank out more of this wild gun talk for y'all. Alright, enough of that. Let's get back to it. The case that could change everything. So here's the deal. Wolford versus Lopez is coming out of Hawaii, and it's a big one. After the Supreme Court handed down the Bruen decision in 2022, most of us figured states would finally have to respect the right to carry. Hawaii went the opposite direction. They passed Act 52, a law that basically turned the whole state into a giant, sensitive place. We're not just talking about courthouses or schools. They banned carry in beaches, parks, bars, banks, restaurants, and most businesses you'd step into on a normal day. By some estimates, over 90% of public spaces are off-limits. Now here's where the fight starts. The folks challenging this law are saying the state flipped the Constitution upside down. Instead of carry being the default right, Hawaii made it the exception. Unless a property owner goes out of their way to post a sign saying guns are welcome, you're automatically banned from carrying there. That's not a small tweak. That's rewriting the whole framework of the Second Amendment. And here's why everybody's watching. The Supreme Court still sits at a 6-3 conservative majority. Justices like Clarence Thomas and Sam Alito have already shown they're ready to push gun rights further than Bruen. If they take Wolford, this could be the moment where the court lays down a clear line about what states can and can't do when it comes to restricting carry. Now, to really understand why this case matters, we've got to roll back and look at the big decisions that paved the road here. That means Heller, McDonald, and of course Bruen. The road here. Heller, McDonald, Bruen. All right, let's rewind for a second and talk about how we even got here. None of this fight in Hawaii makes sense unless you know the big cases that laid the groundwork. First stop was the District of Columbia versus Heller back in 2008. That's the case where the court finally said out loud what a lot of us already believed. The Second Amendment protects an individual right to own a gun. D.C. had a flat-out handgun ban, and the justices tossed it. They made it clear that keeping a firearm in your own home for self-defense is a core constitutional right. Then, in 2010, came McDonald versus Chicago. Chicago had its own strict handgun ban, and the court struck that one down too. The important part here is that they said the Second Amendment doesn't just bind the federal government, it binds the states as well. So cities and states can't hide behind local laws to strip away your right to own a firearm. Fast forward to 2022, and you get New York State Rifle and Pistol Association versus Bruen. New York had this proper cause rule, where you basically had to beg the government for permission to carry in public. The court said no way. Justice Clarence Thomas wrote that if a state wants to regulate guns, the law has to line up with America's historical tradition, going back to either 1791 or 1868. That test from Bruen is exactly why Wolford versus Lopez matters so much. It opened the door, and now states are pushing back hard. Next, we'll look at how they doubled down instead of backing off. States push back after Bruen. After Bruen came down in 2022, you'd figure states would take the hint and start lining up with the court's ruling. Instead, the exact opposite happened. New York rolled out the Concealed Carry Improvement Act, and it was packed with new restrictions. They banned carry in churches, bars, subways, parks, stadiums, and even Times Square. They went further by flipping the rules on private property. Unless the owner posts a "Guns Allowed" sign, you're not carrying there. Hawaii did the same thing with Act 52, only more aggressively. Beaches, banks, bars, restaurants, most businesses, you name it, it's off limits. When you add it all up, more than 90% of the state is a no-carry zone. That left people who followed the law with permits still shut out of everyday places. Other states like New Jersey, Maryland, and California piled on with similar laws, and pretty soon, federal courts were split. Some judges stepped in and blocked parts of these new restrictions, saying they stretched way beyond what history supports. Others let them stand, which left folks with completely different rules depending on which state line they crossed. That patchwork is exactly why Wolford versus Lopez matters so much right now. Hawaii isn't the only state with these kinds of laws. but it's the one that pushed far enough to land in front of the Supreme Court. And now the justices are going to have to sort out some tough questions. Wolford's core questions. Wolford versus Lopez comes down to two issues that sound simple but cut right to the heart of the Second Amendment. The first is this: can a state flip the rules and say you're banned from carrying on private property unless the owner goes out of their way to post a sign saying guns are welcome? That's what Hawaii did with Act 52. Instead of the right to carry being the starting point, the state made the ban the starting point. If you've got a carry permit in Hawaii, you're still locked out of most places you'd normally go. The other question is about history. In the Bruen case, Justice Clarence Thomas laid out that any modern gun law has to line up with America's historical tradition. The problem is that courts don't agree on what history counts. Some say you've got to look at 1791 when the Second Amendment was ratified. Others point to 1868 when the 14th Amendment kicked in and applied the Bill of Rights to the states. That gap matters a lot. In 1791, there were very few restrictions on carrying in public places. By 1868, there were more examples of states and cities trying to crack down on it. And this isn't just Hawaii's problem. States like New York, New Jersey, California, and Maryland wrote their new laws on the same foundation. However, the court's answers to these questions will ripple far past the islands. What's at stake nationwide? When I look at Wolford versus Lopez, the biggest thing that jumps out is how much is at stake for folks like us across the whole country. This isn't just about Hawaii. If the Supreme Court rules for the challengers, it could wipe out the idea that states can slap a sensitive place label on almost every square foot of land. That means carrying becomes the norm again. I could walk into a restaurant, a park, or a mall without feeling like I'm breaking some ridiculous rule. I've spent time in both kinds of states, and the difference is night and day. In a constitutional carry state, there are 29 of them now. I don't need a permit to conceal my firearm. I can go about my day without second guessing. But when I travel to New York or California, suddenly I'm looking at maps, reading signs, and trying not to step in the wrong spot. It makes law-abiding gun owners feel like criminals for just living their lives. If the court swings broadly here, the only places likely to stay off-limits are schools, courthouses, and maybe polling sites. That's a short list, and honestly, it lines up with what most folks already accept. For me, that would mean carrying my pistol isn't some logistical headache. It's just part of my normal routine. And that's why the other side is fighting so hard. They know one strong ruling here could level the playing field for every single gun owner in America. The opposition's arguments. The folks defending laws like Hawaii's Act 52 are throwing everything they can at the wall. State attorneys general, big city mayors, and groups like Everytown, Brady, and Giffords are all in the mix. Their line is pretty clear. They say guns don't belong in places where crowds gather or where alcohol is flowing. So they point to bars, concerts, sports stadiums, playgrounds, spots where they believe firearms make things more dangerous instead of safer. To back it up, they're waving around research. One of the studies they like comes from JAMA Network Open, which states that states with stricter carry laws see lower rates of gun homicide and suicide. That doesn't end the debate, but it's the evidence they'll lean on when they're standing in front of the justices. They're also playing the history card. Their spin is that the founders couldn't have pictured today's world, where millions carry compact pistols in packed cities, subways, or shopping centers. Because of that, they argue the court should let lawmakers build new sensitive place rules to match modern life. This is the clash. One camp says the right to carry has to be the rule. The other camp says safety demands wide carve-outs, and the court's going to have to decide which vision sticks. The likely outcome, and what's next. So here's where things stand with Wolford versus Lopez. Everyone wants to know how the Supreme Court is going to handle it. The court is still 6-3 with a conservative majority, and that alone makes people think the challengers have a real shot. Justice Clarence Thomas wrote the Bruen decision, and he's been clear he wants the court to draw a hard line on what states can and can't call sensitive places. Alito, Gorsuch, and Barrett have leaned the same way, which sets the stage for a strong pro-Second Amendment ruling. But there's always Roberts and Kavanaugh. They've shown they're more cautious. In Bruen, Kavanaugh signed on to an opinion that said, yes, states can regulate, but the rules can't gut the core right to carry. That's why I think we might see a compromise. The court could strike down Hawaii's sweeping bans, but still leave room for schools, courthouses, and maybe polling places to stay gun-free. If the court takes the case this term, we'd probably hear arguments sometime in 2025, and get a decision by mid-2026. That's not far off. And whatever the ruling looks like, it's going to be one of the biggest Second Amendment decisions since Bruen. I don't think Wolford will be the last word either. Challenges to so-called assault weapon bans, magazine limits, and even ammo restrictions are already moving through the lower courts. Wolford could be the domino that sets the rest in motion.